welcome to the morning session. We have a panel of 3 speakers on legal history of minorities. MOHSIN Alam, RAZAK Khan and RAJARSHI Ghose. It's the same 20 minutes for each presenter and 10 minutes for the discussion towards the end. So may I request MOHSIN Alam to please make his presentation.
Thank you to all the organizers. It has been a wonderful 2 days. Okay.
Yesterday's session is already on YouTube.
Then maybe I should keep these things.
No, good. Now our students are not there.
Sure.
Wherever they are.
And it's particularly exciting for me to come back because this is what I'm going to present is derived from a part of my dissertation, and before I'd started my field research, I had come here, I'd spoken to and presented here in the faculty, so hopefully the people who were there could just tell me if at all there's been any improvement since. And it's exciting to be on this panel because there are many common themes which we have discovered over the last day and a half, and hopefully we'll pursue them in the discussions henceforth. So what I plan to present is an argument related to the contemporary political mobilization around Muslim quotas on the ground, as well as the role of legal discourse in that political mobilization. And there are multiple strands of this political mobilization or demand for Muslim affirmative action. The one I intend to focus on this presentation is about quotas for Muslims as a group. Many Muslims had already been covered under the existing caste-based quota regime, which was implemented in the early 1990s under the Mandal Commission report. And many poor Muslim groups, occupational groups, are already included in that regime. Apart from, of course, Hindu caste groups, which were much more predominant in those lists. But what the demand in this case has been is the demand to extend that regime from using religion apart from caste as the unit of giving affirmative action and quotas. And since 2004, for those people not tuned into this controversy, the central government and a variety of state governments have introduced Muslim affirmative action. And these policies have been justified politically as well as legally on the basis of a number of state-instituted commissions or inquiries, most predominantly the Sajjar Committee report. And the Sajjar Committee report had found that the Muslim community on nearly all counts was the most backward, what it called a socio-cultural community, apart from the Dalits and scheduled tribes. And it ended up suggesting a wide category of affirmative action benefits, but short of quotas. The subsequent report recommended, went one step ahead and recommended quotas for the community as well. And alongside with being politically controversial, these recommendations and their somewhat partial implementation in different states and by the central government has also received an extremely contrasting judicial response. So some judges have struck down these policies as being unconstitutional, but they have disagreed amongst each other. The argument of the opposition being that affirmative action for Muslims as a religious group is unconstitutional. But what was interesting is that Sajjar's finding, this particular report's finding, were not new. The most prominent example being the 1983 Gopal Singh Committee report, which had similar findings, which made similar recommendations. But what was new in 2006 was not only the widespread mobilization of Muslim groups around the Sajjar Committee report and its recommendations, but also the endorsement of a significant section of the Indian political elite. Consider, for example, Prime Minister V.P. Singh, who implemented the Mandal Commission report and the caste-based regime in late 1980s, early 1990s. He did not even know, reportedly, about the existence of Gopal Singh Committee report. When we come to 2006, Prime Minister Manmohan Singh makes these policies as the fulcrum, pivotal policies of his government. Of course, a lot has changed since 1983 all the way to 2006, political mobilization, electoral considerations being the chief factors. But what I want to emphasize in this paper is something different that happened by the time we reached 2006. I wish to argue that Muslim quotas came to be demanded, articulated, and perceived based on a changing conception of what group identity, and in this case minority Muslim identity, denoted. As I'm taking such a committee report as a particular moment. Unlike before in 2006, Muslim groups have been demanding quotas not as a minority religious group, but as a subordinated group by staking claim to the evolving meaning of constitutional equality. This distinction, subtle as it may be, has evolved over time in Muslim claims. I argue that the evolving articulation of Muslim quota demand reflects a shift from what I call representational claims that were based on insular group identity to what I call equality claims, where socio-political marginalization is foregrounded. In this evolution, groups have creatively appropriated constitutional categories, most importantly, varying interpretations of secularism and equality. As I hope to show at the end, newer conceptions of equality came to be creatively employed to dislodge, at least there was an attempt to dislodge, the entrenched interpretations of secularism. And this process was marked by an intense and contested democratic dialogue among the partisans and critics of the Muslim quota demand, most prominently the actors within the Muslim community. My aim will be to bring out the subtle ways in which the form of articulation of these demands shifted within the register of law. And I hope this argument would be of interest to the people in this gathering. I hope so, primarily because of two factors. One, historians in particular have been concerned about altering, evolving formulations of group identity, especially in the colonial era, and I want to, in a way, push that inquiry to somewhere closer home. And the other is methodologically, I decenter my analysis away from what we ordinarily perceive as legal spaces, courts and legal institutions, to social movements and democratic politics as a place which carries and channels legal conversations. And hopefully at the end I'll also point to how perhaps this discussion points to and gives an account and explains the divergent judicial opinions which these policies have received. I will go over my argument in three different moments, starting from the constitutional founding to 1960s, when there's a revival of representational demands from prominent actors in the Muslim politics, and subsequently in the post-Mandal era. Moving on, secularism, of course, has been a part of very contested academic political debate, but what often is missed out is the role which secularism, both its political and juridical forms, had on minority political claim making. Constitutional secularism, to perhaps go back to many of the themes which are quite prominent in the literature, emerged during the Constituent Assembly deliberations as a direct response to the problem of minorities. It was principally framed on the tension between two competing conceptions of minority representation in the post-colonial constitutional state. As per the first view, which saw India as a fragmented, even compartmental society, representation was to be mediated by the community. Reflecting this view, the colonial constitution provided special safeguards to minorities and reservations and representation. The religious minorities, and Muslims in particular, insisted on what Farzana Sheikh identifies as descriptive representation. Muslims viewed themselves as a single unitary community with exclusive interests, monolithic and internally undifferentiated, and the society as constituted by a mosaic of fixed communal groups. These are her words. The Constituent Assembly, with its preoccupation with national unity and social cohesion, came to reject this notion. It adopted substantive representation as the organizing principle, making religious identity irrelevant, or at least they wanted to make it irrelevant for political representation. But it recognized religious minorities to have their own culture and provided rights of cultural autonomy for from state interference. Thus, constitutional secularism entrenched, and I claim, a specific constitutional ordering of religious identity. It recognized the sacral concerns of religious groups, but not any form of political economic claims based on minority religious identity. And this conception drew the line between legitimate and illegitimate expressions of religious identity, what I call Muslim culture identity. I can elaborate it later. And this conception of identity warranted legitimate claims of cultural autonomy and thus insulation from the state, but stigmatized any political economic claims based on religious identity. The valence of this constitutional ordering, I claim, was beyond juridical, and we might not have time to go deeper into it, but a very good example of this would be Jamiat Ulama al-Hind around the time of independence, which was a prominent organization then and continues to be. And Jamiat accepted Constituent Assembly's proposal of defining secularism like this, and in fact, crucially, it decided to withdraw from political activity, restricting itself only to religious, cultural, and educational rights and duties. I'll just flag, because these issues also remain the dominant mode of claim making for many decades after independence, and perhaps we can have a conversation about that. So this restricted domain of political action, which I've claimed was engendered by constitutional secularism, dominated the agenda of Muslim organizations for the next 3 decades, but things started to change, albeit feebly, by 1960s and 1970s, when larger number of Muslim organizations started making these representational claims again. They argued that the diminishing Muslim presence in government, communal violence, and what they perceived to be growing discrimination against Muslims warranted quotas. Notably, though, the form of these articulations remained within the mold of representation, similar to the Muslim claims before independence. So, for example, in 1967, we can multiply these examples, but one organization being Mushawarat, which came out and proposed proportional representation and electoral reform to accommodate Muslim claims. And in 1972, Jamiat reversed its historical position, especially after independence, against religious-based quotas. And many other organizations joined this chorus. These representational claims were substantially distinct from the constitutional equality claims, which I hope to describe later. Firstly, these claims demanded proportional representation for Muslims as a group. While the experience of social, political, and economic inequality was an important background for these claims, this experience in itself did not constitute the content of the demand. This was because, secondly, representational claims understood the Muslim community as a distinct and monolithic group with its own exclusive interests. Like the pre-independence demands, these articulations understood the community to be internally undifferentiated. This explains the early resistance of the partisans of the demand to proposals of giving quotas for subgroups among the Muslims. And thirdly, these demands represented a specific imagination of the relationship between the state and the citizen. The representative claims not only saw the political society as divided among various distinct communities, but also saw the constitution as a contract sustaining the relationship between these concrete groups on one hand and state on the other. And I'm leaving out, I'm dispelling with the evidence in this matter, but there's a lot of debate and discussion and resolutions about how the constitution itself is imagined in these discussions. One important consequence of this articulation was that it sidelined the relevance of social stratification as the perspective of interpreting the Muslim condition in India. This was further compounded by the kind of objections which these demands received. So, for example, the opposition argued that that constitutional secularism limited the recognition of religious identity only for the purposes of cultural autonomy and religious autonomy. The argument was that acceptance of this kind of demand would be recognition of Muslims who are Muslims. This is like the headline of Times of India, which violated secularism, which generated social division. And most instructive response, I suppose, and one I can go slightly deeper into, is the reaction of Ram Vilas Paswan and his notes to the implementation or non-implementation of Gopal Singh Committee report to the Parliament. And he's the same person who was in charge of implementing, the minister in charge for implementing the Mandal Commission report. And in his view, quotas, and I quote, exclusively for the benefit of course, Ram Vilas Paswan has changed his position by the time we reached 2006. But in late 1980s, this is what he says. Quotas exclusively for the benefit of religious minorities were against the very basis and fundamental policies of equality and secularism enshrined in our constitution. They would violate the basic spirit and structure of our constitution. And there are multiple examples of how this demand was perceived at that time. The neglect of social stratification in the Muslim quota debate was soon to change. And Mandel brought caste and social hierarchy at the center of reconceptualizing constitutional equality. This reformulation also had an impact on a wider set of social groups, including members from within the Muslim community, and the most prominent being the Pasmanda Muslim movement, or the backward class Muslims. By 1960s, many sociologists studying Indian Muslims had started to note that the community also reflected caste-like or caste stratification, and often it was divided as Ashraf and Ajlaf. Mandal Commission did not take up these insights perhaps as deeply as it should. It left Muslim social stratification deeply underdeveloped. And what Pasmanda intervention has done is to complicate that idea of Muslim social stratification. And it was definitive to interpret Muslim caste and also to interpret social backwardness within the Muslim community. So firstly, this intervention, among others, interpreted the existing caste-like categories as a form of social stratification among Muslims, because it was not ordinarily perceived as a form of definitely constitutionally relevant form of social stratification. And secondly, they secularized this social stratification in the light of Mandal by proposing that the sociological category of occupational communities as Muslim caste, marked by the asymmetry of social and political power, while discarding the privileged religious doctrinal understanding of Muslim society. Of course, the Pasmanda activists, among others, came up against the demand for affirmative action for Muslims as a group. And the crucial component of the Pasmanda constitutional critique was an articulation of the conception of subordinated Muslim caste in the light of Mandal. Here was one of the most important contributions of the Pasmanda objections. They made social stratification central in the future debates around Muslim quotas, and importantly, introducing these concerns primarily in the form of constitutional equality. They claimed that all Muslims did not share a common experience of social, political, and economic marginalization, and consequently, Muslims as a group did not qualify as a subordinated identity within the meaning of equality. They claimed only the Pasmanda groups within the community shared this experience of marginalization, and only these sub-Muslim caste identities could be the legitimate targets of quotas and affirmative action. This critique disrupted, I claim, the representational claims of Muslim quota. They denaturalized the monolithic conception of Muslim community, and they also made the representational nature of the Muslim demand increasingly implausible. Consequently, it left the partisans of the Muslim quota to grapple with the notion of social stratification among Muslims, and eventually as a religious identity in the ongoing debate. How much time? The 1990s saw a conflictual exchange among the partisans of Muslim quota and the critics led by the Pasmanda activists. While the Pasmanda claims were accommodated earlier, eventually they transformed the very form of the demand. And within this exchange, a different conception of minority religious identity based on shared socio-political subordination rather than pre-political religious unity started to emerge. Muslim advocates started pointing out the specific forms of subordination that Muslims as a religious minority community suffered in India, linked with asymmetries of political and social power, bias and discrimination and violence, made them into a composite class within the meaning of constitutional equality. This became the groundwork for a more developed idea of minority religious subordination within the meaning of constitutional equality. And the contemporary articulation of Muslim quota demand, I claim, should be placed within this evolving debate. Muslim actors, of course, have deployed such a committee report and other government studies to argue that religious identity is a form of social stratification in India, and Muslim identity reflects a status of subordination as it encodes concrete forms of marginalization unique to minority religious identity in India. The Muslims need affirmative action, not as a religious group, the argument goes, but as subordinated group within the meaning of equality. To quickly conclude, I propose that, considering that I had written this initially as a response to the ongoing legal debates around affirmative action, I propose that this way of conceiving the evolving idea of minority identity as coming from a notion of representation all the way to equality, is also something which helps us understand how the differing judicial opinions, what is the basis of the differing judicial opinions. And without going in greater detail, I'll just pick up two cases. So for example, if we look at a wide set of petitions which have been filed against the Sajjad Committee report and against the implementation of Sajjad Committee report. And one case I pick up is this case filed by the Rashtriya Mukti Morcha in Delhi. This is an ongoing case and it has been replicated in many other high courts, which has challenged the very constitution of Sajjad Committee report, and the courts have not answered this question. But if we look at the arguments made by the petition, what the petition argues was that it was illegitimate to give special treatment to Muslim minority over and above, quote unquote, the cultural autonomy rights under the constitution. And it replicates, it reproduces the same conception of constitutional equality where there is the segmented or partial recognition of religious identity. And similarly, the High Court decisions, which have been much more skeptical about treating Muslim affirmative action as constitutional, have been unable to accept the conception of Muslim religious minority identity as a form of subordinated identity within the texts of social backwardness, within the texts of equality claims. They continue to treat them as monolithic. And we can go deeper into it. For example, one of the courts says that Muslims are not homogeneous. And that only comes from the idea that as if they are making a representational claim. But this is not a representational claim anymore, at least argued from the Muslim side. On the other hand, when we look at the courts, the judges who've been much more receptive and accepted Muslim affirmative action as constitutional, they're the ones who have started to adopt the conception of minority identity as a form of subordinated identity, as one which had shifted from the register of representational claims to equality claims. I'll pause here. Thank you so much.
So this paper is part of a larger project looking at ways of thinking about India and Germany, both in terms of the question of archives.
So it's called Modern India and German Archives. So the project's concerned with archives as ways of thinking of questions that seemingly are not connected. But through this workshop, I like to think of this question through the category of concept. Now, concepts as ways that perhaps also can bring historians and scholars concerned with law. So I would not be talking about law, but I would have, I'll come in the end to think about concepts and its implication in terms of thinking about minority cultural preservation, debate about minority institution, and the larger question of citizenship. But I shall, during the paper, approach this question through the formation of the concept. And the concept that I'm interested in is the concept of minority and the question of culture. And I want to suggest that the debate in India about minority culture, which is framed within the nationalist logic, could perhaps be more fruitfully understood beyond boundaries, particularly taking into account Indo-German conceptual history. So my project is concerned with particular engagement of Indian or South Asian Muslim intellectual with German thought. Now that's a long history which begins, of course, with German philologists' interest in India, not just in Indology, but actually quite strongly in Muslim intellectual formation, Arabic, Persian, and Urdu. So the famous philologist, scholar Alois Sprenger's work, both at the Calcutta Madrasa but also at Delhi College, is one of the finer example of this philological engagement. Of course, prior to that, Goethe's engagement with Persian sets the tone. Now in 20th century, there is a reverse trend, which is turning of South Asian Muslims to Germany as possible alternative side to imagine concept and ideas beyond imperial intellectual formation. So, and the most famous example being Muhammad Iqbal, who actually studied in Germany with the famous Arabic scholar Joseph. Well, it's an interesting parallel. So the first Arabic scholar at Aligarh was actually a German Jewish scholar, Joseph Horowitz, who taught Arabic and was actually quite crucial in formation of Islamic studies as a discipline in Germany at Frankfurt, but also more interestingly at the Hebrew University later on. So interestingly, the minority intellectual, the Jewish intellectual from Germany were the pioneers in building this formation. Iqbal, of course, studied with the famous German scholar Fritz Hommel, who also interestingly supervised the important Jewish intellectual Gershom Scholem. Both of these remarkable students of his went on to then think of nationalism through the lens of mysticism. So it's perhaps it's a German contribution for imagination of nation, both of Pakistan and Israel, that happens at this time. But I want to look at the work of Abid Hussain, who's considered as a nationalist historian in India, who also studied in Germany at this time. So following Amir Mufti's suggestion, I want to suggest that the problematic status of minority as it emerged as the Jewish question in Germany should be traced back and seen as in its reappearance and persistence as the Muslim question in post-colonial India. Now, this entangled intellectual history of Indian Muslim scholarly writing on the issue of Muslim question and the minority integration in India shares a deep affinity with the German thought, particularly on the subject of national culture, Kultur, self-cultivation, education, which would in German be the concept of Bildung or Erziehung, and the citizenship ideas that dominate the intellectual debate on the Jewish question and emancipation debate in Germany. And I want to follow that debate about emancipation to the debate about national integration in post-partition in India by looking at the writing of Sayyid Abid Hussain. So crises are productive temporalities that produce new entangled history. Sayyid Abid Hussain was one of the many Indian, perhaps I should speak. I can speak without the mic. Okay, so I want to come to his important text that Abid Hussain actually wrote. He studied in 1920s Weimar Berlin and sort of engaged. So in his earlier work, he studied with Edward Spranger, an important educationist psychologist. But I want to trace his work, an important text that he wrote, as the post-war context, which states itself has an interesting history. It was initially this was before partition, but sang post-passage Germany to speak, not just speak, translation, as now this is of course the text which we now know as the National Culture of India. Now the book has an interesting history. It was initially written as Indian nationalism and national culture in the Islamic communist or communist in 3 volumes in 1946 before the partition of India. However, as noted by Hussain in the preface of the revised and translated English version, The National Culture of India, it was not just revised but also fundamentally so as to take a more comprehensive view of the problem. And I'm quoting Hussain here, that to solve the political cultural synthesis which is necessary to ensure our national unity and freedom that could be achieved. Moreover, the revised Urdu title of the book was Qaumi Tehzeeb Ka Masla, so the question of national culture. The violent partition of India did not solve the Muslim question. Instead, it created a long-lasting cultural question marked by suspicion of Muslim in India and the question of minority integration into national culture. Now, beyond nationalist frame, it is important to situate the translation, its recasting within the larger global Cold War history and the politics of national knowledge production, particularly about Islam and minorities. Now, this text was translated in, under a fellowship of Rockefeller Foundation. And it's interesting to read Rockefeller Foundation's statement, and the archive is actually available online. So the Rockefeller Foundation reports in the field of humanities in 1953 emphasized that, and I quote, sought to identify and stimulate new cultural growth, and toward this direction, Rockefeller Foundation gave support to intellectuals for writing and interpreting recent history so as to enable better understanding of international problems. Now, Rockefeller Foundation Fellowship allowed Hussain to translate this text, but Rockefeller Foundation also funded another scholar at this time. This is, of course, the famous Pakistani nationalist historian, Ishtiaq Hussain Qureshi, who at Columbia University sort of worked on his important text called The Muslim Community of the Indo-Pakistan Subcontinent. Now, it's interesting that both these texts, funded by Rockefeller Foundation, come to completely different conclusion. Hussein's project is one of thinking of Islam, situating it within the larger history of India, and work toward the integrationist project of Indian Muslim as part of Indian culture, whereas Qureshi comes with another two-nation theory argument of thinking as Islam is fundamentally different and something that should not be consumed within the logic of nationalism. Now, what I want to suggest here is that these engagement of minority problematic emerges because of the other category, which is the category of national culture. Now, the concept of culture is something that I think has been largely seen within nationalist lenses. So, Abid Hussain's work, for example, is situated within the historiography of nationalist Muslim, including his teacher Tara Chand, who's seen as the father of nationalist historiography. But I want to in fact suggest that the category of national culture itself has a particular way in which the Urdu intellectual engaged not through the civilizational discourse, which is something that was crucial before. So C.M. Naeem, for example, has written on the concept of Tamaddun, which is recast in dialogue with French work on civilization. I want to here suggest that the shift from the Tamaddun discourse to the Tehzeeb discourse in Hussain is a particular engagement with the definition of culture, which is fundamentally tied to the category of nation state, which is the sense of the German concept of Kultur, and which separates itself from the French discourse of civilization. So Kultur project is fundamentally tied to a practice of cultural politics that must contribute not just self-cultivation through education, the builder concept, but something that also must be connected with the nationalist or nation-building project. Now, it is in that context that I think the text engages with the idea of Muslim cultures as being fundamentally tied to the national culture formation. And this has to be achieved through the politics of education. And as we know, Jamia Millia Islamia is an example of that particular engagement of Muslim intellectual formation shift from Aligarh to the nationalist movement of 1920s. But Jamia actually, I would argue, has two stages of engagement with nationalism. One, of course, is the Gandhian-led first phase, which is an alliance building in the Khilafat period. But the second stage is, of course, the one led by Zakir Hussain, Abid Hussain, and others, which I would argue is a second stage of integrationist. It's important to know, and Rajarshi will be talking about Abul Kalam Azad, that the post-partition field of education and culture was fundamentally, in a strange and ironical way, was dominated by Muslim intellectuals. Whether it's Abul Kalam Azad as the education minister, Zakir Hussain, Abid Hussain, K.G. Sayyidin, or Humayun Kabir, all of whom went on to be important figure in the policy making and write both in the field of culture and education ministry. So I want to sort of think about that particular problematic and solution that was suggested by, in fact, the category of the new nationalist Muslim who were responding, of course, to the post-partition discourse of minority integration. So I think it's a stage where Mohsin was talking about the fact that when can you represent yourself? The post-partition logic required that Muslims should not represent themselves. They must merge into a category where they are represented by. So this entire discourse of national integration is quite crucial in this nationalist Muslim intellectual formation. And Abid Hussain in the book actually goes at elaborate detail of how that should be achieved. So he gives policy suggestions, especially on the role of teachers. So teachers in the German concept of reform pedagogy, which is what that shapes actually Varda scheme or the Nai Talim that Zakir Hussain and the others sort of supported in India, the crucial role there of teachers as the actors of integration. This has to be achieved through what he then goes on to suggest an elaborate program of teachers exchange, cultural exchange through institutions like National Book Trust, but also other services like National Social Service. It's another of one of the fundamental ideas promoted by this kind of new nationalist integrationist project. One of the themes that I want to here explore is again the knowledge production and its politics. So Jamia Millia is an also interesting example to pursue, to think through how knowledge about Muslim culture or Islamic culture is also fundamentally recast to imagine Islam within the category of nationalism. So the Zakir Hussain Institute of Islamic Studies in Jamia that came around in 1970s has a very interesting history. It's a project that was again championed by Abid Hussain and others, Muhammad Mujib being another important actor. Now this other project was itself has to be situated not just within the history of Indian nationalist Muslim cultural formation, but as I show in my paper, that institutionalization of Islamic studies in this time was actually a global process, one that was connected crucially with actually Germany, but also through the role of W.C. Smith, the important Islamic studies scholar, first at McGill and subsequently through his role at Harvard, Chicago. He not only institutionalized and brought people together, sometimes ironically completely contradictory actors. So he was the one who brought Fazlur Rahman to Chicago, but also people from Jamia to McGill. The important thing there is, apart from bringing people together, is also the conceptual question. So Smith is credited with the idea of comparative religion and developing a new kind of Islam, a modernist Islam that works with the logic of nationalism, but also modernization and liberalization. And this discourse of modernization and liberalization is something that completely shapes the project of Islamic studies being attempted at Jamia. A large part of that articulation can be seen in a journal that is launched by Abid Hussain called Islam in Modern Age, in which in fact a lot of scholars, including Smith, but also I want to argue the Islamic studies scholarship of Germany was a crucial actor. Indeed, Hussain went to Germany in 1960s to raise not just intellectual support, but also financial support for this project, Anna-Maria Schimmel being a important connecting link. Now, we know Schimmel's own transition to America at Harvard was indeed promoted by Smith, and Schimmel was the connected link with Jamia. So you could actually find a lot of engagement of Schimmel's with Zakir Hussain and Abid Hussain. They also shared interest in Ghalib's poetry. So apart from these institutional connection, what I want to then come to, and I think I could sort of perhaps now start concluding, is to think of this question of both the category of the minority and its problematic, what we would now think of as the cultural question, within the fundamental demand of nationalism. Now, this is a project that emerges if you think of the Jewish question and the entire debate about emancipation and Jewish project of taking Bildung ideal. So George Moshe's wonderful work on German Jews as the one who would think of education or emancipation through integration, in some way subsuming the particular community identity for the ideal of citizenship. Now, in some strange avatar, this is an argument that appears in post-partition India of the only possible way of achieving citizenship through the ideal of transcending your own Muslimness. Through the project of, and therefore the very interesting category of nationalist Muslim. So I want to think through how does that category emerges, in what way citizenship ideal, and I think that's where the contemporary debates on Muslim representation become important. Muslim in post-partition India aimed for a project where they would not be represented as Muslim, they have to be. And this, I would actually argue that the Nehruvian discourse, in fact, didn't allow for that possibility. So it's interesting to sort of think through contemporary debate on minority institution and the debate around that. In fact, during Nehru's own time, Zakir Hussain was actually moved to be the chancellor at Aligarh University within this particular tension about the minority institution and the desire for not just national integration, in fact the word was emotional integration. Muslims had to fundamentally change the way they were connecting with the post-partition state. So I think this, I want to think through, and I think the workshop has allowed me to think of the way we frame the question of minority problematic. How do we understand the entire debate about minority institution and the question of citizenship and representation? This, I think, is a question that has to be fundamentally traced actually under the Nehruvian logic of representation, a point that is often missed out in contemporary debates about polarized and politics of BJP. But I would indeed suggest that the Nehruvian discourse, which emphasized so much about national integration, indeed is a moment, productive moment to think about the very question of emergence of the Muslim minority representation question, both in terms of minority institution, but also the category of minority cultural right in its expression. So I think I'll leave it at that, and I'm happy to sort of discuss this further with you. Thank you.
Thank you. We have the last speaker of the panel, RAJARSHI Ghose.
Thank you everyone for being here in such warm hospitality. What I'm going to talk about in my presentation is I'm going to talk about both colonial and post-colonial India and the dynamic transformation of a field of Islamic legal arbitration and consultation which lay outside the bounds of formal judiciary. My paper will focus on the career of a prominent Islamic jurisconsult, Mawlana Abul Kalam Azad, and attempt to map how political change, especially the long-term politics of decolonization, impacted his disciplinary practice of Islamic law. Azad, independent India's first Minister of Education and a leader of the Indian National Congress, was homeschooled in the Das-e-Nizami curriculum and was early on trained to be an Islamic jurisconsult. Since his teenage, it had been Azad's desire to be a mufti, and this aspiration to be an authoritative interpreter of God's law was untouched by the dramatic redirection of his life's trajectory. Throughout his life, thus, Azad functioned as an unattached Islamic jurisconsult and was approached for consultation on Islamic legal issues by organizations and individuals from across South Asia. In June 1921, in the thick of the Khilafat non-cooperation movement, Azad publicly endorsed the efforts of scholars of religion who urged Muslims to resort to privately constituted Sharia courts, such as the Imarat-e-Sharia in Patna, Bihar, instead of the colonial courts, and strove towards a form of jurisprudential apartheid in British India. From that moment then, even Azad's practice as an independent jurisconsult, as a scholar of Islamic jurisprudence who operated outside the institutional parameters of the colonial judiciary, became a component of his anti-colonial politics. Apart from such religio-legal problems which had direct bearing on institutional politics, as in jurisconsult, Azad was also required to rule on questions which rose from the humdrum of quotidian life in Muslim South Asia. For example, in the course of his long career, Azad had to grapple with questions besides the ones of the routine ones on norms governing prayer, marriage, and divorce. He had to grapple with questions such as whether inoculation for medical reasons annulled ritual fasts, how to go about marriage of conjoined twin girls, whether Friday sermons could be delivered in non-Arabic local languages like Bangla, whether the practice of birth control was halal, permissible, whether it was permissible for a person to drink his wife's milk, and finally, whether it was permissible to invest in or make use of life insurance, usury, Provident Fund, radio, telegram, telephone, and photography. Azad's political adversaries often question the sincerity of his faith and his credibility to function as a jurisprudent. For example, in 1939, the editor of Zamindar, Mawlana Zafar Ali Khan, who was a supporter of the Muslim League, ended his poem The Sarai Mead, taking a swipe at Azad's religious integrity. So this is a free translation. Huh? If you want to spin the spinning wheel, the charkha, do so with the hand that dispenses justice, daste qaza, which is an allusion to the mufti's vocation as somebody who dispenses justice. And curd the fiver of the hypocrites of India. Ask Abul Kalam why he has forgotten the Kaaba following his visit to Gandhi at Wardha. However, as far as Abul Kalam Azad's practice of Islamic law is concerned, I believe the most urgent question that needs to be explored is the issue of his methodology. Apparently his father, Maulana Khairuddin, was a dogmatic Hanafi Sunni Muslim, but Azad himself made no secret of his deep respect for some of the architects of the traditionalist Ahl Hadith school of Islamic jurisprudence like Muhammad al-Shawkani of Yemen, Muhammad Ismail Dehlavi and Sayyid Nazir Hussain Dehlavi. Several of his close associates like Maulana Muhyiddin Kasori and Ghulam Rasul Meher were active members of the Ahl Hadith religio-legal school, and he often counseled them on doctrinal and organizational issues related to their movement. For these reasons, it is imperative to explore the methodological aspects of his religio-jurisprudential thought and to ascertain the extent of influence that Ahl Hadith movement had on Abul Kalam. But that is beyond the scope of my presentation today. In this paper, I explore aspects of Azad's career as an Islamic jurisconsult and attempt to map how political change, especially the long-term politics of decolonization, impacted his disciplinary practice of law. The paper focuses on two juristic rulings, one from 27th April 1921 and the other from 1954, which Azad had issued to arbitrate in intra-communal disputes arising over management of two mosques, the Nakhoda Masjid of Calcutta and the Ahl Hadith Masjid of Maler Kotla in the Sangur district of Indian Punjab, respectively. In his Nakhoda Mosque ruling, Azad echoed the position he had already voiced in his Khutbat-e-Siyasiya or Masajid-e-Islamiyya of 1913 and ruled that all mosques were by definition political spaces and that it was religiously valid to arrange political and non-political, political or ghair-political assemblies in them, and that since the lifetime of Prophet Muhammad, mosques had functioned as parliament of Muslims, Musalmanon ki parliament. However, in his short ruling from 1954, Imam al-Hind, Mawlana Abul Kalam Azad ka faisla aur Maler Kotla ka niza, he opined in unequivocal terms that it was imperative that the Imam or the prayer leader of a mosque remained unaffiliated to and stayed clear of all political and religious movements of the times. I investigate in this paper the considerations that could have brought about this radical disjuncture between the Maulana's position in 1921 and 1954 and the circumstances that might have radically altered Azad's perception of a mosque being an intrinsically political space. Was it that Azad had come to believe that there was no moral ground for a separate Muslim politics in India post-1947, and the radical Islamist vision that he had once articulated had been completely subsumed in the post-colonial agenda of the nation-state? Was it that his experience in the decade leading up to decolonization had convinced Azad that religious was appropriately a matter of private practice and ought not to have any standing in public life of the Republic? This presentation engages with some of these questions and seeks to understand how the long-term politics of decolonization impacted Azad's practice as a jurisconsult and his more general role as an arbitrator of India's Islamic traditions. Azad's ruling on the matters related to the Nakhoda Masjid of Calcutta, the Faisla Muqaddama Jama Masjid e Calcutta, was first published by the custodians of the mosque in circa 1921 itself. The Nakhoda Mosque came into being in around 1856. Its affairs were dominated by members of the Western Indian Kutchi Memon mercantile diaspora living in Calcutta, who at that time operated their business from the Chitpur neighborhood of the colonial metropolis. Haji Muhammad Zakaria, one of the trustees of the mosque, was also the leading member of the Kutchi Memon caste organization in the city. This overlap of Memon caste organizations such as the Memon Jamaat Trust and the Memon Khairat Fund and of the management community of the new mosque had significant consequences for the future. The mosque came to be identified as a community project of Kutchi Memons and consequently was popularly known as the Nakhoda Masjid. Nakhoda meaning sailors, since these people were heavily into shipping, hence the appellation Nakhoda. Muhammad Zakaria, the leading member of the Memon community, emerged as such a towering presence in the affairs of the mosque that the new mosque popularly came to be known as the Zakaria Masjid. Upon the death of Muhammad Zakaria in 1873, his mantle both in the Memon community affairs and the mosque committee was inherited by his son Nur Muhammad. After a couple of decades, Nur Muhammad was at loggerheads with some of the other members of the Kutchi Memon community, and in 1907, a legal case was started in the High Court at Calcutta. Nur Muhammad passed away in 1915, and another member of Zakaria's clan inherited the mantle. In 1918, there began a conflict between the custodians of the Nakhoda Mosque and the gentleman who had been appointed by them as the Imam or the prayer leader of the mosque. And in circa 1919-1920, another legal case was started in the High Court. As the Sufi Sheikh, Azad's father, Mawlana Khairuddin, had been a significant presence amongst the Kutchi Memon diaspora in Calcutta. Even though they were themselves not Kutchi Memons, both Khairuddin and Azad's older brother, Ghulam Yasin, were buried in the Kutchi Memon community graveyard in the Maniktala neighborhood of Calcutta. After he returned to Calcutta from his internment in Ranchi in 1921, Azad claims that both the conflicting groups realized that it had been wrong on their part to bring a dispute over a matter related to a Waqf endowment, an institution governed by Islamic law, to a non-Muslim court, a Gair-Muslim Adalat. Following that, the two conflicting groups together withdrew the matter from the High Court and appointed Azad as the sole arbitrator of the case so that he could issue a ruling in the matter which was consistent with Islamic law. One of the original questions that brought the conflict over the Nakhoda Mosque to the fore in 1921 was whether or not the custodians of the mosque had a right to sack an imam or a prayer leader who was popular and revered amongst the general mosquegoers. Thus the Maulana dwelt at length on the religio-legal principles governing the office of an imam of a mosque. Azad regretted that the fact that the imamat or prayer leadership was no longer the exalted institution that the Sharia envisaged it to be. Salaried imamat, ajir wa tankhadar imam, of 20th century South Asia did not quite approximate the exalted office and the great institutional norms governing it that the Sharia puts forward. Azad then meticulously detailed the moral characteristics that the Sharia expected a mosque prayer leader to embody. So both the Mufti and the Imam, through a cultivation of the habitus, has to embody the Sharia. So, thus, according to Azad, the mosque imamat was meant to be an exalted and sacred rank and an embodiment of knowledge and religious practice. In fact, Azad went on to the extent of claiming that in true and subtle senses, mosque imamat approximated the rank of communal leadership, Jamati Peshwai amongst Muslims. In earlier times, only people who had distinguished themselves for their pious fear, knowledge, sincerity of religious practice, fidelity, devotion, purity qualified for the exalted rank of communal leadership. Mosque imamat was not a profession in itself. It was an entitlement of the people who had reached high religious and political rank. Thus, in seats of Islamic caliphal government, the Darul Khilafat, the caliph himself would lead the congregational prayers. In the conquered territories, the governors appointed by the caliph would perform that function. For smaller mosques, the Islamic State would appoint respectable people of the respective neighborhood to the rank. Such imams were much unlike the salaried imams of 20th century South Asia. Their imamat was a function of their religious stature and political rank. However, Azad continued, things began to change soon after. With the global decline of Islamic civilization and religious system, and especially after the extension of Islamic regimes and their substitution by non-Islamic regimes, the mosque imamat was professionalized. According to the Mawlana, one of the reasons that brought about this devaluation of the office in South Asia was the extermination of the Islamic State in the subcontinent. And he throughout refers to the Islami Hukumat. After all, the principles that the Sharia had laid down for the choice and appointment of the imams of the mosque were no longer applicable to South Asia, Hindustan, since the Islamic government, the Islami Hukumat, there had ceased to be. Azad then claimed that practice of Islamic law had to change with the transformation of political regimes, and jurisprudential practices had to evolve, keeping in mind the demands of time. Implicitly, what Azad claimed was that any Islamic jurisconsult practicing in British India had to keep in mind that South Asia was no longer a dominion where Islamic regulations were in force or a domain of Islam, a Dar al-Islam. Rather, British India was a Dar al-Harb or a domain of war, a dominion where Islamic regulations were no longer in prevalence, and it was mandatory for a Muslim to migrate from the territory. The practice of Sunni jurisprudence had to change with the transformation in the religio-juridical status of the dominion. The two issues were in fact concomitantly tied up. In this particular decade, the religio-juridical status of British India was a theme that Azad repeatedly turned to. In his ruling of May 1920 on the question of migration from British India, Azad had implicitly termed British India to be a domain of war or a Dar al-Harb, a dominion from which Muslims were required under Islamic law to immigrate from. I quote, "After examining all the reasons embodied in the Sharia, contemporary events, interest of Muslims, and expedient counsels, I feel completely satisfied in my perception that for the Muslims of India there is no Sharia alternative but to go on hijrat or migration. Before the war, the First World War, hijrat from India was commendable or mubah. Now, in accordance with the spirit of the Sharia, it has become mandatory or wajib." At one level, there was nothing unique about Azad's ruling about British India being a domain of war. In fact, Shah Abdul Aziz, the foremost Sunni Islamic scholar in 19th century northern India, had declared it to be so right after the British occupation of Delhi in 1803. Even though Shah Abdul Aziz had acknowledged that India had ceased to be a domain of Islam with the extermination of Mughal power, he had not called upon the Muslims of South Asia either to migrate or to perform jihad. In his own words, Shah Abdul Aziz believed that British India was a domain of war because, I quote, "In this city of Delhi, the Imam al-Muslimin, or the Mughal emperor, the leader of Muslims, wields no authority while the decrees of Christian leaders are obeyed without fear. Promulgations of the commands of unbelief, kufr, means that in the matters of administration and control of the people, the unbelievers or the kafirs act according to their discretion. From here, Delhi to Calcutta, the Christians are in complete control." End quotes. Although Azad worked within the same framework of Islamic law that Shah Abdul Aziz had done, he moved on a much different register than Shah Abdul Aziz, and his reasons of why British India was a domain of war and his notions of what constituted an ideal Islamic government were much more idiosyncratic. Whereas Shah Abdul Aziz's principal plank was that the Imam al-Muslimin, or the Mughal emperor, held no power in early 19th century Delhi, and the Christians were in power in the entire stretch of the country from Delhi to Calcutta, and the promulgations of unbelief or kufr were followed in matters of secular administration. I argue that Azad's understanding was shaped by the critique of the promiscuous, by his critique of the promiscuous entanglement of liberalism and empire that the Mawlana had started articulating at this juncture of his political life. In an unsigned editorial in its 17 September 1913 issue, titled "Mourning Humanity Has the World's Wound of Slavery Healed," which was written in the wake of the Kanpur Mosque event of summer 1913, the Al-Hilal, the paper that Azad brought out from Calcutta, challenged the claim that the French Revolution had liberated humanity from the clutches of imperial absolutism, and in fact questioned the moral right of Britain to continue its empire in India. The author agreed, because it's an unsigned editorial, we don't know who actually wrote it. The author agreed that the imperial absolutism was part of everybody's history. The Hindus considered their emperors to be incarnation of God. The Muslims, in their fit of ignorance and absent-mindedness of Islam, called their emperor Zil Allah, or the shadow of God. Even though God remained the creator of life, it was despotic Muslim emperors who controlled it on earth. Imperial commands constituted the law, imperial actions the Sharia. In fact, their edicts abrogated the Sharia. According to the Al-Hilal, Islam's message of no ruler but Allah was meant to liberate humanity from the clutches of Roman, Egyptian, and Persian empires, and to establish the universal human right to powers of government. Finally, the French Revolution put an end to absolutist monarchy, paved the way for parliamentary democracy and rule of law. However, the editorial claimed that the Kanpur Mosque affairs had revealed that the spirit of imperial absolutism was very much enshrined in the heart of the colonial state. In spite of its parliaments and the law courts, on the ground the exercise of colonial state power was very much in the imperial absolutist mode. Thus, even as early as 1913, the Al-Hilal editorial team, which included Azad, evolved a critique of the colonial state in terms of the rights of man, democracy, and rule of law, and was already operating in a register that Shah Abdul Aziz could not have done. Azad's critique of the absolutist policies of the colonial state evolved with his deepening involvement in anti-colonial politics, and so did his faith in democracy. Thus, in his written statement submitted to the Presidency Magistrate in Alipur Court, which was later published in the Urdu tract The Qaul-e-Faisal, Azad claimed that the government under the rightly guided caliphs of Prophet Muhammad was in fact an Islamic democracy, Islami Musawat-e-Amma, Islami Jamhuriyat, where the caliph was no more than a common citizen. Unlike the American Republic, Azad claimed the seat of caliphal government did not have a White House. Even during the autocratic and imperialist regimes, the Shakhsi Hukmrani or Shahinshahi of the Umayyads and the Abbasids, there was freedom of speech in Islamic society, and it was within the rights of a common Muslim to castigate the ruler. Thus, even though Muslims were forbidden under Hanafi Islamic law to rebel against Muslim despots, it was the religious obligation of every Muslim to criticize and castigate the despotic caliphs in public. However, when it came to despotic non-Muslims like the rulers of British India, Muslims had but two choices, freedom or death. The colonial state was no more than an illegitimate bureaucracy, and bureaucracy is there in the original itself, that was out of touch with truth, justice, and aspirations of the people. According to Azad, the Indian Muslim had come to realize that the only way to truth and justice that was open to them was the attainment of Swaraj, the attainment of a national government that was by Indians, in India, for India. Before moving to the ruling of 1954, I would like to highlight one of the major conclusions of the Faisla-e-Muqaddama Jama Masjid Calcutta, which has particular significance for the conclusion of this paper. In the Faisla, Azad reiterated his position that he had already voiced in his Khutbat-e-Siyasi or Masajid-e-Islamiyya of 1913 and ruled all mosques were by definition political spaces. All mosques were by definition political spaces, and it was religiously valid to arrange political and non-political assemblies in them, and that ever since the life of Prophet Muhammad, mosque had functioned as the parliament of Muslims. It will be also salutary to remember here that it was okay, I'll take this out. I will now take up for discussion the ruling from 1954. In 1954, the Ahle Hadith movement in Punjab suddenly found itself in the thick of an intense internecine conflict. The movement's mosque in Malerkotla village of Sangrur district of the Indian province of Punjab had suddenly become a bone of contention. One faction of the Anjuman-e Ahle Hadith filed a case in the High Court of Punjab but the judge referred it to Mawlana Azad. The issue at stake was the question of mosque imamat. An Ahle Hadith scholar of religion from Uttar Pradesh, Muhammad Amid Mubarakpuri, had been appointed as the Imam and Khatib of the Malerkotla Mosque. Maulana Mubarakpuri had been on the job for 2 years when the people of Malerkotla discovered that he was in fact a member of the Jamaat-e-Islami and a follower of Abul Ala Maududi. The aggrieved members claimed that Maulana Mubarakpuri was turning the Malerkotla Mosque into a propaganda center for the Jamaat-e-Islami and refused to pray behind him. One Maulana Abdullah was appointed to run parallel sessions of congregational prayers in the same mosque. In his ruling on the question, Azad ruled that Maulana Mubarakpuri should not be allowed to continue in his office. In fact, anybody who had affiliations to any political movement, not just the Jamaat-e-Islami, but any political movement, should not be allowed to hold that office. A person who had no connections with political and religious movements of his times was best suited for the job. Thus, in 1954, Azad had come to look upon the profession of a mosque imam as an apolitical vocation and a mosque as normatively an apolitical space. According to the Maulana, it was well within the right of a person to join any religious or political movement that was going on in the country, but it was reprehensible that the pulpit of a mosque be turned into a platform of propaganda for any movement. Nothing should be, I'll just finish a couple of minutes. Nothing should be preached in a mosque other than the Quran and the traditions of Prophet Muhammad. My question is, why did this radical change of opinion happen in Azad? What happened between 1921 and 1924 that so radically altered Azad's understanding of mosque as essentially a political space? It is my contention that Azad had viewed British India as a domain of war territory and had considered it imperative to articulate an Islamist political critique of colonial rule. For Azad, the process of decolonization had brought into being a political dominion that he had envisaged in 1922 as a national government for Indians by Indians in India. In 1922, Azad had considered it to be a religious obligation for all Indian Muslims to struggle for Swaraj. Post-1947, Azad probably felt that there remained no scope for a separate Muslim politics. The Islamic democracy had been subsumed in the Indian Republic. Thank you very much.
I'm sure you're running late. So we'll go up to 11:05 or so. So we still have something like 20 minutes for the discussion. So Professor Farhat Hassan.
What particular strains in German thought would explain the emergence of this category of nationalist Muslims, and in particular the kind of integration of nationalism with mysticism that you notice as a salient feature of Muslim nationalism. Often one could suggest that perhaps there's this influence of Nietzsche or someone like, I don't know. But anyway, this needs to be explored as to what kind of strains in German thought would explain this kind of nationalism, which is ego-centered, which emphasizes on elements of faith as constituting nationalism. So I thought this is something that did confuse me. I was also wondering, there were also, the category of nationalist Muslim is an evasive one. Some elements of this kind of nationalist Islam would have an integrationist reference, but there would be others that would actually eschew integration and prefer multiculturalism as the more appropriate frame of reference in diverse countries such as India. So I was wondering the two problems here. One is that what is the kind of relationship that the nationalist Muslims that you discuss had with more homegrown nationalist Muslims, the ulama, for example, or people like Hakim Ajmal Khan, who had a very different tradition, but who came to the same formulation of defining himself as a nationalist Muslim. So what kind of a dialogue or conversation is taking place between these variant forms of nationalist Islam? But I also wondering, is this still an elite category? What kind of a conversation is it having with someone like Pasmanda Muslims, with the common Muslim, the common run of Muslims? And if we refuse to engage with, are you suggesting that the category does not apply to the lower class Muslims?
Is there anything on this, in this particular point?
I had a question to Mohsin as well. Can I? Mohsin, I was actually wondering, I understand this fascinating again, that this politics of Pasmanda Muslims has an element of representation. But I was wondering, what is the internal dynamics to this movement? Is it seeking to rupture the argument of marginalization on the basis of faith, on the basis of the category of a minority, as against caste as a proper category to define marginalization? And if this is what it is doing, then it is obviously rupturing the narrative of the Muslim leadership, isn't it?
Social differentiation of Muslims, the public policy dimension, rather than, one as a matter of history. Probably 30 years later, this would become an issue of history. Now, as a matter of public policy, this Pasmanda movement obviously brings in an element of what you call emphasizing social differentiation within a community, with the reservation implications and with the Article 15, 16 implications, etc. So as a matter of public policy, as a scholar of law, what would be your take, as to the implications of litigations which might already be there or litigations which may soon follow? You see the Pasmanda argument vis-a-vis the community as a whole being socially and socio-economically backward, obviously with reference to some so-called objectively determined criteria, and obviously up to subject to the creamy layer, etc. So I am asking the question, he is probably asking as a matter of history, I am asking as a matter of current affairs, but the question is possibly the same.
Are you asking what my
I would say that, as a scholar, because no doubt you have donned for the time being the mantle of a historian for the purposes of this forum, but as a scholar of law, what would be your public policy sort of reading of the situation? I hope the question is clear.
But first, let me thank you for a rich and stimulating panel, all three speakers whose work I really enjoyed. I have two questions. One is to you, MOHSIN, and it has to do with a local formation in Hyderabad called the Majlis, which is an extremely different and new and in some ways not yet comprehended, properly comprehended formation, political formation that has no parallel anywhere else in India, that kind of presence. How would you align what the Majlis stand for? They're not lower caste, but they are also lower caste. It's a very difficult kind of definition to work with. How would you align what they stand for with the new socio-political, caste-based kind of formations that you are talking about? And moving from there, really the question is about Majlis. How do you see them? How do you understand them in relation to the framework that you have set up? And moving from there to you, Razak, the whole issue of integration as it came up in the nationalist movement and the immediate post-national, of all minorities, not just Muslim minorities, but predominantly they were the paradigm minority, if you like, has turned out to be such a sham that there was something rotten at the very core of that proposition. Okay, and one of the other things is something that this gentleman in front of me, his name is was also just mentioned. The idea that the earlier formulation was elite, that it was so elite that it was a formulation of Muslims who were almost Hindu and who were certainly not poor or disadvantaged or in any way culturally inadequate. And that this is something that you need, I mean, without building that into your discussion, there is no way in which we can, a figure like Abid Hussain, for instance, I mean, he was awesome in every respect, maybe with no parallel in the Congress party, or no person of that stature and learning and insight and composure and ability to articulate, you name it. Look at the cultural capital somebody like that carries, and look at the same time at his total alienation from Muslims at large. So I'm really saying, how would you speak to each other, and are there not contemporary issues that we need to stitch into?
Shall we allow, and then we'll allow the participants to respond.
No, Mohsin, want to react to Naved Bhai also, and then since it's a history thing, don't you think that this whole question of affirmative action, which was very much on the agenda of the Constituent Assembly, and there has been a consensus that we would have some kind of reservation for the minorities, was eventually dropped because the Christian members of the Constituent Assembly insisted on the inclusion of word propagation in the freedom of religion, which was, they said, their central tenet of their religion. And in the bargain, that word came in, and they were promised that they will have a freedom to convert people. This reservation was given up. And of course, there were Muslim members who thought in the Constituent Assembly that reservation is something very bad and we should not be taking it. And two, this whole question of cultural rights which you are talking, if you look at Article 29, the heading is misleading because it says of rights of the minorities, but in the text, the expression used is any citizen having a distinct language, script or culture shall have a right to have its own. And this happened because in between the partition happened, and this word minority was dropped and citizen was brought in, and in 29-2, and Naved Bhai is aware that that led to a lot of litigation on 29-30 relationship, that no section, there shall be no denial of admission on the basis of religion, race in any state-aided institution. The word there was also not citizen, it was a minority, that minority will not be denied admission, Yes, that's right. That is the point. We are talking of aided institution. And then don't you think that if you look at the litigation which happened over the decades on the question of Muslim reservation, you had three major decisions here. First a 5-judge bench, then another 5-judge bench, then a 7-judge bench, and then there was a bench on Sachar committee thing also, that was the OBC reservation, but I am not on that, I am on Muslim reservation. Each one of them, they said there can be a reservation for Muslims if they qualify as a backward community within the Indira Swani formulation. And each time the court did not strike down the affirmative action for Muslims on this ground. They said you did not do proper research in terms of identifying backwardness. You did the survey in 3 days, you gave it to, not on the basis of the Backward Classes Commission, but on the basis of some minority commissionerate report, that kind of thing. But in terms of law, as in Indira Swani also, they said that the entire community can be backward. So it is possible that you can have a reservation for the whole Muslim community if you prove on Indira Swani's parameters, and there are as many as 11 parameters. Of course, my take is that those parameters are now outdated, because they are talking in terms of water access and in terms of kacha makan and whether you have electricity or not, in terms of development, and this strict rigid limit that the distance between the general category and the backward category should be of 25%. So what is your take on this, that should we revisit those parameters itself? And Supreme Court has to do it, of course, but the possibility of reservation is still there for the entire community if you are able to scientifically prove that the whole community is backward.
So I'll start with answering the public policy legal questions first. I wanted to spare the historians this. No, I do. I wanted to save the harder for later. So let me start with the problem. The problem is that the ongoing litigation and the judgments around Muslim affirmative action and quotas do not fall in any clear pattern at all. Also, these judgments are not clear when it comes to their positions, and that shouldn't surprise students of law in this country, because judges make it a virtue of being extremely unclear about what their position is. But you are right that there has been a mild, and it's an interesting phenomenon of a certain kind of depoliticization of the juridical process itself, which is that rather than directly engaging with the legal normative issue of whether such reservations are constitutionally valid or not, there is a pushing of these questions to certain empirical questions, right? So instead of saying yes or no, it is, well, maybe you should have done, and literally the Andhra Pradesh High Court judges are saying things like, your sample size should have been bigger, you should have gone to more houses. So those are the questions which lawyers are particularly not trained to judge at a legal normative level. But there are still some commonalities. The first is, there have been judges, both in Andhra Pradesh and outside, who have said two things. One, they have said that Muslims do not constitute a homogeneous group. And that is always linked very closely to the idea that, well, they are not homogeneous group on a superficial level, but maybe if you find empirical evidence, then maybe we'll figure it out, right? So it is linked, but there's already a concept, I'll link this up, there's already this conception that they are not a homogeneous group. But that's question begging. Homogeneous in terms of what? Right? So that is an important question which judgments do not often talk about. This is related to the second thing, which is, even the Mandal criteria has a lot of unstated assumptions, which is resolved only when it reaches the Supreme Court. So what Justice Reddy says, quote unquote, integral connection between poverty, social backwardness and caste. These things, statistical method is particularly incapable of showing this integral method, right? So one can show that a caste is socially, economically backward. How do you prove the integral connection? And by the way, that has been the long dilemma of affirmative action jurisprudence in India. So there is a particular narrative content in how we read evidence. That is the question of homogeneous. The problem in these judgments is that that narrative is missing. The judges who are uncomfortable with Muslim affirmative action and Muslim quotas, that you may show that they are backward, but is it because they are Muslims? Or is it irrelevant whether they are Muslim or not? So for example, what a judge in fact, one of the judges in one of the Muralidhar Rao case, the second one, who says poverty is an unfortunate situation which can strike any person irrespective of their religion or not. So there's an arbitrariness to that. And interestingly, just a small point, Justice Bilal Nazki says, to respond to your question of sort of revisiting these criteria, and he says, you know, when it comes to caste, we can think of untouchability, access to public amenities, etc. But when it comes to religion, especially Muslims, we have to think of other grounds. So for example, what is the literacy level? How many women can come out? What is the system of parda? So different communities will have different kinds of social backwardness. So we need to revive it. So sure, that's a valid debate. And I think there's an endless debate to what extent should we think of new ways to judge social backwardness. But definitely in the case of Muslim affirmative action, the problem has been, for those who have been unsympathetic, is a question of narrative. And that is what I'm arguing that is why it's linked up, which is that the larger historical politics around conceptualizing group identity is deeply connected to how these judges are also approaching it. So if we perceive of Muslims as merely religious sacral community, then we are missing out on the political economic marginalization. The judges who have been receptive of Muslim affirmative action are those who have been in a way, who have recognized the shift in articulation of Muslim group identity. Now what my opinion about it is that I'm sympathetic state-wise, maybe not national-wise, and again this would be a long debate, but that is only once there are clear grounds of the socio-educational political marginalization which is marked by religious minority identity. I don't think the same parameters can apply. A backward, socially and educationally backward caste group cannot have the same criteria as socially, educationally, politically marginalized religious group. Because the kind of marginalization which religious groups suffer is very different from what caste groups suffer. So that reconceptualization has to happen. I think that amount of work has to go into it. The kind of violence, the kind of... in what?
In terms of backwardness.
Yes.
Permissible formulation, educationally
And socially backward. But there is nothing obvious.
Socially backward criteria should be different for caste groups.
Yes, yes. It is, that conceptualization is already happening. Otherwise, and this is not just a problem with Muslims, it's also a problem with caste. That idea of social backwardness has to be problematized much more, but I'm sympathetic to it. I'm sorry, I'm taking too much time. I'll just quickly respond to Professor Hassan. I can re-emphasize that because that is what I argue as well. The Pasmanda or backward class Muslim resurgence is fundamentally opposed to the so-called upper caste Muslim assertion. And a lot of it is political because these groups are already accommodated in the backward class category, most of them. Minority based? You mean Muslim marginalization as a group? Definitely, and that has been the till very recently. We'll have to sit and wait what happens over the last in the next 2-3 years. But till I was doing my field research, definitely coming both from Maharashtra and Bihar, the arguments are explicitly opposing upper caste arguments about disrupting their political leadership, because that political leadership is based on an idea of a Muslim community and representing that Muslim community. And they have been explicit about it. The idea has been to revive a certain low caste solidarity across religious groups. It has been about disrupting they have been very critical of what they think is secularism in the sense, so I owe some debt to them, the idea that secularism entrenches religious identities, a Muslim as a monolithic identity, and there's a challenge to it. But the motivations are philosophical, of course, but these are political motivations because these are concrete battles of political leadership which are being fought, especially in UP and Bihar. I'm sorry, I've taken too much time. Okay, I'll respond to it if anybody else.
I'll try and answer to this really important question. I think the question of the nature of leadership is actually connected with the nature of the thought itself. So indeed, it's the German elite Jewish discourse in its own original formulation had completely marginalized the Eastern Jews. So the German Jews' idea of integration was the Bildung ideal fundamentally is based on exclusion. So I think it's sort of is in that sense originary. But it of course acquires a particular Indian Ashraf turn because it works very well with the existing forms of authority. Now, I think while the nature of authority actually changes, and I think the transition from what Barbara Metcalfe called the Rais or traditional form of elite authority, something that Hakim Ajmal Khan represented, to the second stage. So I think the category nationalist Muslim itself is changing. I don't think it's a static thing. So people like Zakir Hussain and others would, be actually not deriving power through the traditional form of authority. And I think Rajashri's paper is important for that reason because I think Abul Kalam Azad is in that sense crucial. They needed that person. Congress needed somebody like him. If he didn't exist, he would have to be invented. So I think it's crucial to therefore look at Azad as the link actually from the traditional Rais form of Ashraf authority to, let's say, the bourgeois or the salariat class of authority that comes later on. So that's in terms of the class nature. And I think the question of, I want to come back to the question of the disruption or complete absence of link with the class and caste question. In my paper abstract, I had actually mentioned K.M. Ashraf case, which I couldn't speak because of time, and I think that is crucial. So Ashraf is somebody who actually turns away from this nationalist liberal discourse. He turns to actually the other idea of Marxism in Germany. So he turns to Marxism as a way of thinking of both the caste and class question. Ashraf was actually from the neo community that then brings the question of caste and the other traditional form of exclusion and the class question too. This is something that, of course, is missing in this discourse because of also, I think, the German Jewish thought, which actually emphasized the Bildung discourse is based on the idea of cultural leadership. So it fundamentally believes that there has to be the class of people, what they call the new man, that must represent community. Communities need these people. The kind of question that Mohsin and others have been, the Pasmanda movement ask, is something that is not implicit, and this is something that was the case actually even in the Jewish intellectual formation, which is why actually a lot of Jews turned to Marxism as within the German Jewish community there was that split. So I think in that sense this mirrors actually, and I think that's where I think the category minority thought itself has to be problematized. The minority thought itself is based on creation and exclusion of other minorities. So I think that's really, I guess, both the nature of the thought but also the class position. But perhaps Rajashri would like to say something on this linkages of traditional form of authority, because I think Azad is somebody who actually is quite crucial in this.
The question on nationalism in this.
Okay, I think that this is something that is actually quite central to Iqbal and Scholem's work. Of course, both of that particular formulation of nationalism, mysticism is connected also. Of course, Nietzsche is crucial, but I think actually there is a strong turn of Kant also. So Sprangers, who Abid Hussain worked with, Hussain also, by the way, translated Kant's critique of pure reason and work on secularism, nationalism. Now, we do know that in German tradition, this particular fetishization of the people or the culture with the idea of the nation is quite crucial. I also think the unwritten looming personality that is here is the figure of Goethe too. And Goethe is somebody that actually Hussein translates, and that's how this sort of enters the idea of education as something that sort of connects the inner. So the implicit thing in Bildung is the two-layered nature of Bildung, which is the self-formation and its complete sort of crucial connection with the larger, so the inner and outer dialectic of culture, which is why I think this particular definition of culture, tehzeeb, is actually fundamentally different from tamaddun, which is then connected with this idea of the German meaning of Bildung and Kultur, which then connects the subject with the larger formation. In this case, quite crucially, it is the nation state. So I think that's where these things get connected. Quite interestingly, in fact, Spranger wrote a famous book called Types of Man. So this is something where he came up with the typology of what kind of men are there, and one of them being the spiritual man, who should also be, and then it is of course connected with the idea of leadership. So I think there are various strands of thoughts. In case of Iqbal, it's certainly influence of Nietzsche and mysticism, but I think a whole set of other thought, particularly the German strand of Neo-Kantian thought, but also Goethe and the idea of aesthetic education, is, I think, entering into all these formulations.
Razak,
Yeah.
Iqbal's notion of the self is in total contradiction with the cornerstone of mysticism, which is annihilation of the self.
Right.
How do they come together?
I think the fact that Iqbal has been, in some strange way, has been canonized as somebody who represents the formation of Muslim thought, first of all, I think there has to be ways in which we have to think beyond Iqbal's and its formulation, and also the way Iqbal is actually read. So in fact, Smith actually, W.C. Smith's work actually talks about two kinds of Iqbal and his appropriation. One is the progressive ways in which Iqbal has engaged with it. The other is what he called, I think, conservative Iqbal, which is another reading of Iqbal. So what happens when the concept of self is then attached with the nationalist project? This is also the trajectory of the Jewish mystical thought. So Schollem's work has been appropriated, and it has been, it's loved now by the Zionists. But so I think there are ways in which a thought acquires a life through, I guess, its interpretation or appropriation. So that's where I would actually make a distinction. Iqbal's thought is also, I think, in engagement with various other thought, French philosophy and Persian mysticism, where again a distinction has to be made. I also feel that in 20th century, actually, there's also turned to a whole set of other issues. Thing that I didn't speak in the paper is, in terms of translation politics, actually, there is a shift from Persian to Arabic, and it has certain implication in terms of thinking about of philosophy and translation of concept. So I guess what I'm trying to suggest is that ways in which we think of Iqbal's, and I would actually say there is not one Iqbal. I would like to go with that reading of Iqbal, that Iqbal is what his readers make him to be. So I guess I'll go with that.
Before we discuss two bits of activity, one, the HAIDER had at one point of time around a dozen what we call faculty members which were from Germany.
Yes.
Now none returned without a German spouse. So you Rajeshri, you see, for an Indian coming on now,
Are you suggesting anything to Razak?
not a very intelligent person. He needs no suggestion. I would, be very surprised if anyone, let's say, anyone from the Alim Tabqa or Alim or a class in India would take Azad to be Jewish counsel. They would take more in exegesis. It's across the border and something very ironically, and it's a very big irony, it's not for recording. It's ironically for very, what you call intemperate classes of the other side of the border that he's taking in exegesis. Probably, sorry, as a Jewish counsel, probably for half his three.
No, but there are compilations of his
No, I
fatwa.
know that. We can discuss that. I have some views and probably something to back up those views also.
larger, just quickly, I think this is a great question, as I have primarily, so Majlis is not very young, right? Majlis has a very long pedigree, and also I don't treat Majlis as exceptional. There are many other groups at all sorts of levels. I think Kerala is one good example where that kind of politics and Majlis might have much more to share with political parties like Shiv Sena than any others in terms of their actual control over the city and how they operate. But all political strategies, including Majlises, there are multiple political strategies they employ, and Majlis also has evolved over a period of time with taking representational claims and eventually fitting them in equality claims. But that is how they have made those arguments. If you look at their statements in 1980s, their resolutions, they came together with other Muslim political parties, they created a National Muslim Front, and the resolutions were primarily representational. But by the time you reach now, especially around the Sachar Committee report, they are articulating those demands in a very different way, which I claim are closer to equality claims. Of course, what they do on the ground and how they activate a charismatic Muslim community, that's a separate matter, and we can have a discussion about that. But in terms of how they make their arguments, that has definitely shifted. By the way, at least I've heard statements that they consider themselves pasmanda and low caste. The Owaisis do. They come out and say, we want Dalit Muslim unity.
I have had some discussion with him. Rest assured.
I'll send you the link on YouTube when he declares he is backward class.
Well, we can carry over the discussion to the tea break, and it remains for me to thank the three participants and the audience. We are running late and we are supposed to come back at 11:30, but I don't know how much time. We have 15 minutes, so we can go 11:35. We reassemble. Thank you.